Hey, are you even allowed to own a medical practice in your state? Well, if you're not a physician, the answer is maybe not. So, this week we're talking about corporate practice of medicine laws, or CPOM. If you're a healthcare practitioner or just a layperson considering starting a medical practice, you may need to look into these corporate practice of medicine laws. In fact, I would say it's essential to understand them because in many states, you may not own a medical practice unless you are licensed as a physician. If you're new here, I'm Scott Radigan. Welcome. And I'm the founder of Functional Lawyer. We're giving legal education to everybody across the cash based, integrative, functional, personalized, precision medicine world. And we're doing so that you can protect yourselves and really serve your patients with clear peace of mind and confidence and just focusing on patient care. So, what is corporate practice of medicine? Well, they basically are in place, and it's a kind of an older thing that has been around for 130 years or more, that are in place to ensure that medical decisions remain under the control of medical providers, free from influence by business interests. Now, today with the insurance model, you might say that's kind of a laughable thing and a little bit archaic. However, the laws still exist in many states. So let's pay attention to what are CPOM laws and how they operate now in the 21st century. So CPOM, or corporate practice of medicine, prevent non-physicians from owning or controlling medical practices. So they leave medical decision-making solely in the hands of healthcare professionals. Now, the intent here is that they will always do what's best for the patient and not what's best for the bottom line. We know that's not always the case, even with these laws in place. However, it's important to follow them. Otherwise, there's lots and lots of consequences. So the specifics of these laws, it's important to remember, vary from state to state. And it's important to know how they could affect your business, especially if you are planning to operate in more than one state. There are a couple of categories that we like to call strict CPOM and flexible CPOM states. So states like Texas, California, and New York are highly strict in their corporate practice of medicine laws, meaning non-physicians cannot own or control medical practices. In flexible states, such as Florida, these are more lenient, meaning non-physicians can own or have the majority of a financial interest in practices as long as licensed physicians still make the medical decisions in that business. So why does this matter for multi-state practices and for healthcare platforms that are non-medical practices? If you're thinking of expanding your practice into other states or launching a healthcare platform, understanding this is critical. Failure to comply in strict CPOM states can lead to fines, penalties, and closing of the practice or closing of the business. So here are a couple of common scenarios to go over just to kind of cement this home. And as always, talk to a healthcare attorney that knows you and your situation to help you determine what is best for you and your situation. So one is non-physician investors. So in strict CPOM states, non-physician investors cannot own medical practices. However, they can still be involved through what is called a management services organization, or managed services organization sometimes, or MSO. So Mike, Sierra, Oscar. So the managed services organization manages non-clinical business operations like staffing, billing, marketing, while licensed physicians retain full control over medical decisions. This arrangement operates through a contract between the MSO and the medical practice. Typically, that contract is called a Management Services Agreement, or MSA. And the MSA outlines the specific services that are provided by the MSO, such as handling day-to-day operations. It also establishes the payment framework for the MSO's services. And very importantly, the payment arrangement must be based on fair market value to avoid any violations of anti-kickback statutes, both state and federal, Stark law, or state self-referral laws as well. And that would ensure the arrangement is compliant with federal and state regulations. This structure is commonly used to comply with CPOM laws. So it's not true that you can't own a practice in these strict states. You do just have to go through this MSO structure with, and in this case especially, an attorney who is familiar with healthcare law in your state or your jurisdiction to help you set up this MSO correctly. For multi-state practices, if you intend to expand across state lines, CPOM laws can vary dramatically. what works in Florida may pose legal risks in California or New York or others. So if your business structure involves non-healthcare professionals as owners, you will need to adapt accordingly and maybe restructure before expanding into more than one state. So a couple of action steps you can use right now to partner with non-physicians or expand into other states. And for these purposes, this non-physician applies to PA and NPs, although California allows NPs to have their own professional corporations and PAs to have their own professional corporations, but you do still want to look into talking to a local healthcare attorney. So know your state's laws. Research the CPOM laws in every state where you intend to operate. If there are strict CPOM states in your plans, use an MSO. That's the workaround. It will take some extra money up front, some extra paperwork, but it will be the legally correct way to do it. And I've probably said it 3 times so far, do consult an experienced healthcare lawyer in your jurisdiction for this one. This is an area you don't want to skimp on. It's one of those where an ounce of prevention prevents a pound of cure, or a stitch in 9 saves time. It's essential to consult somebody with specific experience with MSOs and structuring partnerships that will comply with CPOM laws. It's very fact specific and case specific, so individualized and unique to your situation. So to wrap up, if you plan on partnering with a non-physician, or if you're a non-physician looking to open a medical practice, do check into your state's corporate practice of medicine laws, because that'll have a major impact on how you set up your entity or entities if you have to use an MSO structure. So getting the right legal advice from an attorney is key to protecting your business and ensuring compliance. And these are the things we talk about all the time at Functional Lawyer through our weekly office hours and our practice protection program, or through our complimentary 20-minute consults to see if working with us might be a good fit for you and your situation. So for more like this, please subscribe. If you want to chat with me, go to functionallawyer.com/DC, and let's set up a discovery call and talk about your situation. Thanks, and we'll see you guys next time.